It's 2025 and a new year means brand new opportunities. And for a lot of you out there, I know you've been thinking about one thing over the holidays, and that is starting your own business. But you have so many questions like, how do I get started? How do I come up with a brand? How do I even sell stuff to people? And what am I even going to sell? Now take a deep breath. Shopify has got you. Shopify makes it simple to create your brand, open for business, and get your first sale. And you can get your store up and running easily with thousands of customizable templates. You don't have to be a coding nerd or a design geek to get this done. All you need to do is drag and drop. Shopify also helps with the details like shipping, taxes, and payments from one single dashboard, so you can focus on the important stuff, like growing your business. Established in 2025 has a nice ring to it, doesn't it? Sign up for your $1 per month trial period at shopify.com/truecrime, all lowercase. Go to shopify.com/truecrime to start selling with Shopify today. Shopify.com/truecrime.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my relatable co-host, Brett.
Hi, Alice. It's so good to be with you again, and always wonderful to find out which pun you're going to use at the beginning of each episode.
Did you get it?
No, I got it.
Wow.
Your skills are amazing.
I mean, my skills are not that amazing because they are incredibly predictable, but I'm very excited because you may think that we talked all we could about DNA and genetic genealogy last time, but nay, Brett was like, you know what? I have a lot more I want to say about genetic genealogy, and genetic genealogy, of course, is all about how related you are to those around you and using kind of this family tree or your genetic DNA tree to narrow the pool of probability of what kind of population you may be a part of.
Yeah, well, this has been coming up a lot because of the Brian Kohberger case, which obviously we talked about last episode. We talked about some of the filings that they made in that case, and there was a hearing after that where basically the judge rejected both of those filings and said, hey, we're going to trial in October. So we're going to have to see if that actually happens, see if Kohberger really wants to press this and have a trial in October. I kind of think soon there will be an actual motion to continue and waive the speedy trial deadline and push the trial, but you never know. Maybe we're going in October. But during that discussion, you know, one of the things they did, we talked about the botanist last time. They put the botanist on the stand. And when you followed what was going on Twitter and Facebook, there were so many people, and they come from a good place. Bob Mott is one of them. Being a defense attorney, it's not all that surprising, but who are concerned about genetic genealogy. And they're concerned about it because of a privacy thing. And there's sort of this amorphous privacy concern and whether or not the rights of the accused are being violated through genetic genealogy. And we have talked about genetic genealogy a lot. We had Kristen Middleman from Othram on. We talked to the host of DNA ID, which is a show all about cases that have been solved by genetic genealogy. And it's something, it is a revolution in so many ways, both in crime fighting, in restoring people their identity, in identifying people that we thought we'd never know who they were. Mysteries that are 50, 60, 70, 100 years old. And that is a little under threat by some of the, like I said, I think well-meaning people who have legitimate concerns. But how are those concerns going to manifest themselves? How are they going to be put into action? What kind of restrictions might be put on genetic genealogy? And what is the cost if they are? And so those are sort of the things we wanted to talk about today. There's a lot of really interesting legal stuff about DNA. Jason Blair's asked us to talk about that. We're going to do it eventually. I'm going to talk about it a little bit today, but really this is more sort of a big picture type discussion that we're going to have today.
Yeah, absolutely. So before we get too far, let's start at the beginning. How does genetic genealogy work? It's important to note that when the police use genetic genealogy, they have the suspect's DNA from the crime scene, but they do not get their DNA from a genetic database. Rather, the DNA is entered into the database to see if any relatives are in the system. So let me make sure everyone understands that. No third-party database are the police going to extract like a vending machine DNA. Rather, they see a knife sheath, for example, and extract DNA from it. But because that person is not in the law enforcement system of CODIS, meaning that person hasn't been arrested before, then they won't be able to make a match based on the DNA that they've extracted from the crime scene with the law enforcement database. And that's when they go to a third-party database, which has, you can name all the different types of 23andMe or DNA commercialized databases. So from there, they're not looking for a person to match. Sure, it'd be great if that person happened to commit a crime and also decide to swab their mouth because they wanted to know if they were Scottish or Irish. But usually what they're going to the database for is that there are probably some distant relative that have put their DNA into the database. And here's the thing. All of us are related to someone. And those someone are related to other people, and you can see how that branch gets bigger and bigger as you go further down the line. So, for instance, everyone has about 500 fifth cousins. If any of those fifth cousins pops up in these databases, the researcher finds a common ancestor using genealogy. So your fifth cousin's common ancestor with you is your great-great-great-great-grandfather. Using genealogical data like birth, voting, wedding, census, military, death, and other records. By the way, there's so many records you can find publicly. A tree is built, not unlike what you may have done on something like Ancestry.com, or I'm helping my kindergartner make a family tree right now. From that tree, you can zero in on just who that DNA belongs to with this math problem, essentially. This was the method used to catch the Golden State Killer. His third cousin had entered their DNA into the system, and they produced a couple of suspects, and the police tailed one until they were able to pull some DNA off of trash. No match, but their next suspect, Joseph D'Angelo, bingo.
And this is important because I think there is this... I'm not sure how most people think this works when we talk about genetic genealogy. So much of it is just genealogy. It's the hard work of building family trees. And essentially you are connecting, you have this sort of very, very distant connection with the DNA. Some very small amount of a specific type of DNA hits, and somebody who knows what they're looking at looks at those two pieces of DNA, the one publicly available and the one from the crime scene from the suspect, and says, okay, well, these two people, whoever they are fifth cousins. And from that point forward, it really is, you're sort of building out that tree. And then you're using things like, and we talked about this a little bit in the last one, you build out that tree, you figure out all the cousins, you figure out where they lived, you narrow it down. With the Golden State Killer, the first guy they narrowed it down to, it wasn't him. Turned out not to be him. They did some good old-fashioned police work on that side, got the DNA sample from him in sort of the traditional way that we do that under the law. It wasn't him, moved on, but the next one it was. And that is sort of the key to how this worked. And we talked about last week sort of what the law is. And today we're going to talk more about what the law should be when it comes to genetic genealogy. There are many for whom this whole Kohberger case has raised these privacy concerns that we've already talked about, and the use of genetic genealogy and the use of these databases. And some have called for this to be a precedential case, a case where, it's going to go up from the trial court through Idaho, might go all the way to the Supreme Court about how we use this technology and whether or not the police should have to have a warrant before they can access genetic genealogy databases. There hasn't been a motion to suppress in this case yet. I don't know if there will be, the initial stuff, as we were talking about last time, was really more about making it hard on the prosecutors and the police and the genetic genealogist, making them turn over a bunch of stuff that they don't want to turn over, making a bunch of people have to testify that wouldn't normally testify. They haven't really gotten to the point of saying it should be suppressed, but presumably that would be their next step. But because of some of the things we've talked about, it will be a difficult argument to make, at least in this case. So the problem for them is they might want to create some precedent where you need a warrant to access these databases, but that is certainly not the case now. Information you give to a third party is generally exempted from privacy considerations. If you shared it with a third party, it is fair game for the cops too. We talked about this some with bank records. You see this with cell phone records as well. If you want to maintain your control over information, don't give it to somebody else. Now, there has been a little bit of pushback on this recently where the third-party doctrine is getting reined in just a little bit on its most extreme edges. There was a case called Carpenter, which we really should do because people always get wrong what it says. But Carpenter was a case that was about your cell phone and the way your cell phone can track you every moment of every day, every step you take, record everything you say, like all this stuff, right? And the police were using that, and the Supreme Court eventually said, look, we've always said we're not going to have any privacy interest in this third-party stuff, but this is almost like a tracking device, and it's just too much detail over too much time. Like, you knew every step this guy took for 365 days. That's just too much. We're going to rein that in, and that is the first sort of example of the courts starting to say these traditional doctrines we have, maybe they don't take account of some of our new developments, and we're going to have to start rethinking some of them, at least on the extreme edges.
But even there, the person who has the privacy interest is still the defendant. The defendant in that case was challenging the violation of his own privacy. And people love to talk about the fruit of the poisonous tree. They love that term, and I think a lot of people don't quite understand what that term means. But you only get the benefits of that doctrine if your specific rights are violated, not some third parties. As Jason Blair so succinctly put it, it has to be the defendant's tree. I'm going to stop there really quick. Jason Blair has not been to law school that I know of, but I have been through many law school classes where we learned about constitutional violations and fruit of the poisonous tree and rules of evidence, and I have never heard that description before, the fruit of the defendant's tree, because it is brilliant. And I think any of you studying law out there need to adopt this in your next law school exam, and you will probably ace that exam because it is so succinct, but gets to the point of why the arguments out there of not being able to use fruit of the poisonous tree falls flat unless it's from the defendant's tree.
And we talked about this some last time, but man, if I saw it once, I saw it 1,000 times on Twitter. People would say, I actually screenshotted one of them and sent it to Alice and was like, this is a person who talks on television. They would say things like, well, if the police did anything wrong, then the tree is poisoned and anything that comes from it is fruit of the poisonous tree and they can't use it. And it's like, no, that is wrong. It is not enough. One person was like, well, they might have violated their relatives' rights. Doesn't matter. It has to be, as Jason said, and as I will say until the day I die, it has to be the defendant's tree. And if it's not the defendant's tree, then it doesn't matter if every other tree on the property is poison, you can still get the apples from it. And that is the reality of the law when it comes to this kind of stuff.
So as the law stands now, if someone else, say your 12th cousin, shares their DNA with a third party and the police access it, even if it again is against that 12th cousin's wish and in violation of the company's terms of service, you as the defendant don't have a right to challenge that police action when your 12th cousin DNA ties you to a crime through genetic genealogy.
And there's a reason for that. If you did have a right to challenge this, or if you wanted to challenge this, where would the right to privacy come from? Do you have a right to privacy in the DNA you left on the scene? I think everybody agrees the answer to that is no. And the courts have obviously said the answer to that is no. Your DNA you leave behind at the crime scene is fair game. DNA you leave on a trash can when you throw your trash away, is fair game.
DNA on a cigarette butt that you put out and flick and litter on the side of the road is fair game.
And as talking to Jason, there are cases where, if you're in police custody, they can take your DNA, they can swab your cheek, even without a warrant, which is that's pretty bold, and it's sort of tied to fingerprints. They can do the same thing with fingerprints. As we said before, blood draws appear to be where the courts have said that's too far. Can't get a blood draw without a warrant, but you can get DNA, and we'll talk about that in more detail at some other time. But it is certainly the case right now that to the extent it's the DNA that you left behind, your privacy interest isn't arising from that. Do you have a right to not have that DNA entered into a database and compare it against this other stuff? And if so, why exactly? Can I compare your DNA to the DNA in CODIS? And if I can, which I think, once again, I don't know that most people have a problem with the police when they pull DNA from a crime scene, entering it into CODIS and comparing it. And if I can do it in CODIS, why not the genealogy database? Do you have a right to privacy in the DNA your relatives put into the database? That seems weird. You might say, well, yeah, because part of it's mine, right? That might be your argument. Well, part of that's mine, so therefore I have a right to privacy in that DNA. So even if you can use the DNA you found, you can't use that DNA because I still have a right to privacy over that. The problem is that seems kind of weird since whatever DNA you share with them, the very minuscule amount, you've already provided to the police by leaving your DNA at the crime scene. Do you have a right to privacy in the records and the documents used to build a family tree? Well, now you've just gone off the deep end. Obviously, that's not the case. So it's really hard to identify at what point in the genetic genealogy process you, as the defendant, have a right to privacy that has to be protected. Well, let's assume that you say, look, this is bigger than the defendant. I don't actually care about the defendant. I care about the privacy rights of everyone. And whatever amount of my DNA I share with a relative, by God, I have a right to privacy in that, and it should be protected. And essentially the argument here is, I may not have put my DNA into one of these databases. My brother might have. And when he did that, he's putting my information into that database. And now the police can take some serial killer's DNA and they can compare it to mine through what he did. And that is violating some sort of fundamental privacy right I have. But when you talk about these privacy rights, you get into the hard question. When do you have this privacy right? Why do you have them? Who is violating those privacy rights? So, am I allowed to submit my DNA to a database that is expressly for law enforcement use? So I've decided I want my DNA to be in the database that, say, Othram uses. Othram has their own database. When we talked to Kristen Middleman, she talked about this. It's a database that they use for this purpose and this purpose alone. Solve cases, to identify victims, to find perpetrators. That's what they use it for. And I want to help with my DNA that I own because it's mine. Do I have a right to do that? Or does this fictional person who is claiming their right to privacy, or one of those 12th cousins we were talking about earlier that might be out there committing a murder, do they have a veto on my right to use my DNA as I want solely because they have some small portion of DNA that they share with me? And wouldn't it be at that point when I decide to share my DNA that the privacy violation happens? When I give up my DNA, I have violated your privacy rights to whatever DNA you share with me. And if you say, well, no, the Constitution only applies to the government, so that's not when it happens. Okay. Am I allowed to give my DNA to the police, who are going to use it as a government entity for the purpose of investigating a crime? In that circumstance, where the government is very much involved from the beginning, does that same 12th cousin have a veto on my right? And what if giving my DNA to the police would help find my son or my daughter? Can I authorize them to use it? Just how strong is a random person who I may be distantly related to? How strong is their privacy interest in my DNA and why?
And you see, this line of questioning is real. It's not a straw man at all. In fact, this is why the area of privacy law is so complex, because there are all these questions of where the privacy begins, where someone else's ends, and also who has the right to assert it. And where does that privacy right come from? It doesn't come from nothing. And so this entire kind of line of questioning gets at the heart of why it's not a difficult question to say as simple as the defendant can just challenge it because it's fruit of the poisonous tree. It's much, much more complex than that, because when we have cases where the police have some genetic DNA from a crime scene and it is not hitting any database, how many people do we see on Twitter or online saying, why can't everyone just, contribute a little bit of their DNA so we can get closer to finding the perpetrator? And then you flip it around and people want absolutely no use of these genetic databases, when in fact these genetic databases really touch upon so many more privacy concerns than just the individual defendant who wants to challenge it. And I know some of you may be asking, okay, let's say the defendant can't challenge it, but what if their 12th cousin happens to be like a huge proponent of the defendant and the 12th cousin does have that privacy right and they bring it? Does that affect the genetic genealogy used in the defendant's case? No, because the charges are not brought against the 12th cousin. It's still brought against the defendant. It's a different legal matter altogether. So when you see these debates going on online, people are conflating a lot of different people's privacy rights as well as different legal questions and where they are brought. But say there is a privacy interest that should be protected. By whom? Is it the courts? Imagine there were warrant requirements to use genetic genealogy in a case. How exactly would that work? We know how a search warrant works to go get a search warrant to search your house or your car, but how would it work if the police needed to have a warrant to use genealogy to work on your case? Let's say in order to get a warrant, you need particularity and specificity. You need an affidavit that establishes probable cause that the place to be searched will contain evidence of a crime. How can we ever know if genetic genealogy databases will contain evidence of a crime before we search them? If they always do, then the warrant requirement is worthless. It's just a rubber stamp. But if not, then you could never get a warrant at all, and genetic genealogy is dead. So there's no spectrum with respect to the genetic genealogy database and the requirements to get a warrant. It would be an always warrant is met or never. And even if you could somehow get around that problem when you have an obvious crime, what about for the does? Hundreds of people have been identified through the use of genetic genealogy. In some cases, they're the victims of a crime, and it's obvious that they're victims, but not always. Maybe not even most times. You may find someone and they've been dead for so long that you don't know if there was foul play involved, but you can't identify them. They're a doe. How do you get a warrant then? And what if it was clearly murder, but the case was old and the suspect likely dead? And remember, if your perpetrator is dead, you can't bring charges against them. So are you out of luck there too? Because let's say you find someone who was deceased for 60 years and how do you even calculate what the probability is that 60 years later the killer is still alive? 60 years later, a killer could still be alive. Let's say that person was in their teens when they committed the crime. There is probably a life insurance risk analysis calculation you can do that gives you some probability that that killer could still be alive today. But what if it was 80 years ago, 100 years ago? At some point, that killer will for sure be dead. So is it that all old crimes, if you get over some sort of time period, you're safe as a killer, that you're never going to be found out because the probability of you being alive is nil, and therefore the ability to prosecute you for a crime is also zero? And therefore you could never get a warrant to use genetic genealogy to locate the does, to identify the does, or to identify the perpetrator, even if all the information was right in front of you. It just happened that time had passed.
And look, I think this question of the does is really important because Warrant requirements are a big deal, okay? And when you start talking about warrants, we've been talking a little bit about court orders in the chat. A lot of times you have to get a court order for stuff. If I call up Google and say, hey, I want this guy's email, they'll say, okay, send us a court order and we'll give it to you. And then I just file something and say, hey, court, I need a court order, protective order too, if you can. Send that to me and I'll send it to the company. I send it to the company, they send me the email. No warrants necessary. Nobody has to go swear out an affidavit. No agent has to raise his hand and swear to tell the truth, the whole truth, nothing but the truth. It doesn't have to meet probable cause. We just need a court order. If you want to do that, okay. But when you start talking about warrants, then you're talking about judges saying no, saying not going to do that. You've got to meet the standard. And once again, I guess depending on who you ask and how big the database is, maybe you could get an expert to say it's a sure thing. We're going to find evidence of a crime to the extent genetic genealogy is ever that through the use of the database. But that's a stretch because sometimes you put that DNA in and you don't hit any cousins. 5th, 6th, 7th, 8th, you don't find any. Or you find them and they're useless. They're worthless. You can't do anything with them. That does happen. So how do you get past that barrier if the warrant requirement is what you want? If you want to put that, that is not a low barrier. That is an incredibly high barrier. And it may be a barrier that's so high it can never be overcome. And as Al said, even if you overcome it when it's a crime, when you have these does, you find somebody on the side of the road, you find a body in the woods that's been in there for a long time. You don't know the cause of death. Could have been a murder. Could have just been somebody out there, the elements. You don't know. Can you test them or not? Because it's going to be really hard to get a warrant in that case. And so you're going to have sitting there this database with pretty low privacy concerns that you could access to name that person, but you can't do that because we've decided you're going to have a warrant for that. That's a real cost. And that's one of the reasons we wanted to talk about this, because there are real costs here. And I'm not saying there aren't privacy costs too, or privacy considerations. They are both there. And acting like they aren't, I think is problematic, and not addressing in a straightforward manner just what you are talking about doing. And the real cost that it's going to have, I think is important. And look, for the last 10 years, really since the Golden State Killer, I guess that's been quite 10 years, but genetic genealogy has been a miracle for solving unsolvable cases. And we have seen it again and again. And we have particularly seen it with these does. As I said, it feels like cases, the boy in the box case, that kid was never going to have his name. Ever. And then they figured out who he was through genetic genealogy. It's a miracle. Shutting it down or making it nearly impossible to use will end all that. And unlike many privacy concerns, the cost here is not speculative. And I want to point to a person, an actual person, who I think is an example of this. Rebecca Moran. Now, some of y'all followed this case. She's a mother of 5. She was killed in Maryland on a hiking trail. And she was killed by the same man who violently assaulted a young girl in California during a home invasion. She was killed in August. This young girl was attacked back in March. And when she was attacked, they got the perpetrator's DNA. Now, they entered it into the CODA system, but there was no match. We don't yet know who killed her, and I don't know, frankly, whether genetic genealogy will be used. But here's one thing I think we can all agree on. If genetic genealogy were more widespread, if the technology was more developed and it had been implemented in more ways and there was more funding behind it and more departments had it, and you weren't just using it on the worst crimes of the worst crimes, but you actually were using it on things, this is a pretty bad crime. Home invasion where you assault a child, that's a pretty bad crime. If the police in March had been able to use genetic genealogy to identify this person, they could have arrested them for the crime they committed, and Rebecca would still be alive.
And we raise this only to highlight the real consequences of how we treat genetic genealogy. Even if the concerns about privacy and genetic genealogy are entirely legitimate, there will be a price for protecting them. Genetic genealogy will be more difficult, it will take longer, and in the case of Rebecca Moran, there was time, but from the home invasion in March until she was brutally killed in August, they didn't do genetic genealogy in that case. But imagine if all of these privacy concerns were raised to make genetic genealogy so cumbersome that genetic genealogy would essentially be a dead letter. It would take years, maybe even longer for it to come back, then many more Rebecca Morans can happen before you're able to use genetic genealogy to identify the perpetrator and hopefully stop their violent attacks. And this is not small. It will be more expensive. Testing, as we've said, whether it's drug testing, genetic testing, is already not costless. And if you raise barriers to anything, the cost goes up. That price can be measured in lives, like we've talked about, like Rebecca. The people who commit these kinds of crimes often strike again, like the perpetrator who killed Rebecca Moran. And I believe BK, Bryan Kohberger, would have struck again, but he was stopped after those 4 violent murders, in part because of genetic genealogy.
And look, maybe they would have found him anyway. Maybe they would have been able to put the cell phone together with the car and eventually identify him and do a direct comparison on DNA that way. Maybe that would have happened, but we can't know that for sure. But what we do know is that through doing this, they were able to do those trash pulls. They got his dad's DNA, they compared those, and then that was enough to get an arrest and then do the direct comparison. And that's the other thing, why this is so ridiculous in the Bryan Kohberger case. They have the direct comparison between him and the genetic genealogy. And this sort of goes back to that whole fruit of the poisonous tree thing. I don't know that anybody is saying that Bryan Kohberger's civil rights, privacy rights are violated by the use of genetic genealogy. They're trying to say, well, somebody else's privacy rights are violated, and maybe this is the way to protect them. This is a very rare thing in the law. It's only in a couple of areas where you do this. One of them is jury duty. You guys all know that if you strike African Americans from the jury because of race, that could overturn the conviction of the defendant. And that may seem strange because it seems like whose rights are being violated here? And the Supreme Court actually kind of struggled with this. Like, why are we overturning his conviction because this person's rights were violated? And at the end of the day, they basically said it really is the right to serve on the jury that's being violated, not so much the right of the defendant. And the way we're going to do this is we'll overturn convictions if you do it. And that'll be sort of the prophylactic rule that will protect these rights. But it's very rare when you do that. And essentially what you have is you have people like Bryan Kohberger trying to say, look, I want to use other people's privacy rights to protect me from being uncovered in cases like this. Even though the people who actually put their DNA in these databases, unless you could actually prove that the police violated the terms of the agreements, which they probably didn't. They probably used a database where people willingly gave their DNA. Those people who willingly give their DNA, obviously their privacy rights are not violated because they agreed to it. So you really have to do this very attenuated thing where people who don't donate their DNA to these databases, but I guess you find the 5th cousin's DNA, the 5th cousin of Bryan Kohberger, and then the 3rd cousin is the one. He's like, somehow his privacy rights have been violated, and we got to protect his privacy rights by letting Bryan Kohberger exclude the evidence. I hope that this strikes you as how weird this would be if that was something that you could do. But that is essentially the argument, and it's what the argument has to be if you want to somehow make this a constitutional issue. And so I think it's just important when you hear this debate, hold people to a high standard. It's the easiest thing in the world to wax poetic about the 4th Amendment and the right to privacy and wave around the Constitution. It's harder to engage with the actual cost. And that is a cost to privacy if genetic genealogy continues to expand, but it's also a cost in real lives if it doesn't. And I think that's something we need to grapple with. And one thing we talked about, where should this sit? You know, people are asking some judge in Idaho to make up some new privacy protection. This is, if there was ever an issue for legislation, it's this. This is the kind of thing where, you know, we have a democracy where we get to not everything just has to be handed down to us from all the gods in robes who sit on courts and tell us what we can and can't do. We can actually have legislatures in the states and in the federal government come together and make some decisions. If you're concerned about things like health insurance, and people are always worried about this, if you give your DNA to one of these companies and they find out that you have a genetic disposition to get sick, what if an insurance company gets into that somehow and then won't give you insurance because you're going to be more expensive. There are all sorts of protections that you could make here. There are ways to randomize data. We've started doing that with geofences, which we've talked about before. There's a privacy concern with geofences because it catches so many people's information. And so what Google has started doing is when they give us a geofence, they don't say Alice's phone was here, Brett's phone was here. They assign them randomized numbers. So basically, all you see is these randomized numbers, and then you have the number sort of you're looking for, and you can compare those and see if that's, and then they'll uncover it for you. And they'll say, okay, well, this is the user you're looking for. Go get them. There are ways to deal with this, but a warrant requirement makes no sense and is an axe when you need a scalpel. And I hope people remember that. One thing we are going to put in the show notes, a great article on this is from the National Institutes of Health, NIH.gov. It's called Why We Fear Genetic Informants, Using Genetic Genealogy to Catch Serial Killers. It's by Tennille Brown. It's a great article. I read the whole thing. It lays out some of these privacy concerns. Brown is a JD as well as having a very sophisticated understanding of DNA. So they're able to both discuss the legal aspects of it, how the technology works, but also the privacy concerns that have been raised and why those privacy concerns are probably overblown. A lot of the same things that we discussed tonight.
Well, I hope this helps at least raise for you the relevant questions you should be asking when having this debate. And look, like we said, these are complex questions that require some thought rather than just an axe to come at throwing around terms like fruit of the poisonous tree. And so we hope that you guys are a bit more informed about what we are at risk of losing here and the real concerns that we should have about the potential of stopping real perpetrators and identifying victims who otherwise may never be identified. With that said, Brett, do you have any other thoughts?
Well, this won't be the last time we discuss this. Like I said, Bob Mott is on the other side of this. He wants a warrant requirement for this stuff, which, I mean, if I was a defense attorney, I probably would too, because this stuff is killer in so many cases. And Kohberger's going to be one of them. I mean, this is going to nail him to the wall because they were able to do this. And I can imagine why, if you're a defense attorney, you don't like this technology and you would want to limit it. So we may get him on the show sometime to talk about this. And we'll be talking about it more. I mean, as this case develops, if they file any motions to suppress, we'll take a look at those. We have discussed it before. We discussed it in the last episode. So if you didn't listen to the last episode, we talked about it then. We'll be talking about it again. There's so much law here. And this is another thing. People say things like this is a question of first impression. It is not at all. There is so much law going all the way back to the founding of the country about privacy under the Fourth Amendment, how it applies when it doesn't apply, that this will grow out of. I mean, this is new, but it's not. It's like saying, are text messages protected by the First Amendment? Well, how do we know? Because, phones are brand new. They've only been around for 20 years. And what the Supreme Court does is they're like, well, you had a right to privacy in the satchel on your horse, so you're going to have a right to privacy in your text messages on your phone. That's the way they always do this, and they'll do the same thing here. They will analogize this backwards. They'll use precedents, and to the extent they need to carve something new out, the way they did in Carpenter, which is the case we got to do. We'll do that soon. Is what you'll see. So this is not a case with no precedent. And in fact, if you watched the hearing, when the defense is talking about this and they've got the genetic genealogist, at one point the judge is like, exactly whose privacy rights are you guys worried about? Because it doesn't seem like it's the defendant who it needs to be if you're going to talk about this here in my courtroom. And I think that's just an issue that's going to keep coming up. I will say this. If you go back and listen, I think to our DNA ID, though I might have raised it with Kristen Middleman, I said this would happen because they always talk about how they don't want to be in court. It's just leads and all this other stuff. And I said, look, some defense attorney is going to use this to challenge a search warrant or an arrest warrant. They're going to do it. It's going to happen. And this case, I don't know if it's the first one, but it's certainly the biggest one where you're getting that kind of challenge.
Well, thank you guys. If you have additional questions, like Brett said, I think there are many other issues we can discuss. And as this is raised in either the Coburger case or another case, we will certainly discuss them. And we are happy to answer any questions that you may have, because I know this may have raised even more questions about privacy concerns and genetic genealogy. Write to us at prosecutorspod@gmail.com. Reach out to us on the social medias, Instagram, Twitter, Facebook at prosecutorspod. And we love hearing from you guys. We love hearing from you by email, social media, about legal briefs, as well as our other podcast, The Prosecutors. So until next time, I'm Alice.
And I'm Brett.
And this is The Prosecutors Legal Briefs. You know what I've been trying to do today? I have been trying to plan a birthday party for my almost 6-year-old. And I thought I was like mom of the year because it's August right now and his birthday's in October. And I called all these places to
Is it all booked?
everything's booked. I was like, who is booking their party 2 months in advance? And so that's why I didn't text you, but I texted your wife. And I was like, if we have a Friday afternoon birthday party, will you come?
Yeah. It's probably a bad sign for us to plan our daughter's birthday party in like 3 weeks.